Introduction to Company Law. Sources of company law can be divided into two, which are legal sources and non-legal sources. Legal sources. The principal source is the Companies Act 2016. This Act of Parliament applies to all companies, though certain types of companies are exempted from specific provisions. Non-legal sources. These codes do not have the force of law. For example, the Minister together with the ROC issued the Code for Ethics for Company Secretaries and the Code of Ethics for Company Directors in July 1996. Next, we are moving on to the classifications of companies. There are four types of companies, which are limited, unlimited, private, and public companies.
A limited company is a general form of incorporation that limits the amount of liability undertaken by the company's shareholders. It refers to a legal structure that ensures that the liability of company members is limited to their stake in the company by way of investment or commitments. Section 10 Clause 2 says that a company is limited by shares if the liability of its members is limited to the amount, if any, unpaid on shares held by the members. In a company limited by shares, its member has either fully paid up on his shares or otherwise. Where a member of a limited company has fully paid up on his shares, the general principle is that he will not be liable for the debt of the company. A member of limited company has not fully paid up on his shares. He may be called upon at any time by the company to pay the unpaid portion. When the company is wound up, and the assets of the company are insufficient to meet its liabilities toward its creditors, the member who has not fully paid up on his share will be called upon to contribute. Thus, the member of a limited company knows his maximum liability. Limited by guarantee, a member's liability is limited to the amount he agrees to contribute in the event the company is wound up. Section 31, Clause 1 requires a company limited by guarantee to have a constitution which shall contain matters prescribed in Section 38.3, namely, the company is a company limited by guarantee, the object of the company, the capacity, rights, powers, and privileges of the company, the number of members with which the company proposes to be incorporated, other matters required by the CA 2016, and any other matter as the company so wishes.
Unlimited companies. An unlimited company is very much like a regular private company limited by shares. The main difference, as per the Companies Act 2016, lies in the unlimited liability of its members. In case of an insolvency, the creditors will be able to use the personal assets of the directors and shareholders in order to pay off the liability. Advantages to unlimited companies are as follows. Number one is confidentiality, as the financial information of the unlimited companies is not made available for public record. Second is improved management. The unlimited liability in unlimited companies encourages careful risk management. Number three is creditors' confidence. Since the shareholders and directors are responsible if the company is liquidated, then creditors can have increased trust that the company will not borrow more than they can afford to pay back. Number four is flexible share capital options, and this is due to less restrictions imposed on unlimited companies compared to limited. The disadvantages to unlimited companies, on the other hand, are number one, and most importantly, unlimited liability. Number two is missed opportunities due to low-risk approaches, and number three is that not many people understand it. And as many experts say, number four, the advantages don't weigh up to the disadvantages. Regarding the formation of unlimited companies, they're not much different from their counterpart limited companies, but the difference lies in that the unlimited company has to state that it has or entails unlimited liability.
We move on to private and public companies. What is company? Companies are entities that transact business in a variety of ways, from major corporations to small local businesses. Companies provide goods and services that we all use and consume.
Section 11 of the Companies Act 2016. A company limited by a guarantee shall be a public company, and a company limited by shares shall either be a private company can be divided into two, which are private and public. Private companies that do not share their stock on Bursa Malaysia is called public company, which is not listed. Section 15, Clause 1 of the Company Act 1965. A private company requires share capital memorandum or articles of association must contain restriction on the right to transfer shares. There are two conditions. Only a company limited by shares and not guarantee may be a private company. The number of members is limited to only 50. Due to these restrictions, a listed company must be a public company because the shares of listed company must be freely transferable, there must be a spread of shareholders and thus not limited to
company
and every officer who was in default would be guilty of an offence, the company would suffer the risk of being converted into a public company. These are the consequences under the CA 1965. The company and every officer in default also imputed with the commission and offence under the CA a company limited by 17 cannot be a private company and equally incorporated only as a public company. All companies limited by guarantee are public companies under Section 11 Clause 2. It can be a company limited by shares or guarantees, or it can be an unlimited company. It can have more than 50 shareholders and it does not listed companies or companies whose shares are listed in the Bursa Malaysia. The shareholding of a public listed company cannot be concentrated in a few. There must be a spread of shareholders. One of the benefits of being listed on the stock exchange is the company may raise funds from issuing shares to the public as well as have access to the public as well as
Here we would like to demonstrate
the difference between the private and public companies.
We will be talking about related companies. By classification of companies, the topics are holding and subsidiary companies, ultimate holding company, wholly owned subsidiary, and other related companies. Holding and subsidiary companies, a Malaysian holding company is only considered as an attractive investment if the profits are exempted from the capital gains tax. Next, before setting up your holding company in Malaysia, there will be a few other rules to observe. As per the Companies Act, business can only be considered as a holding company in Malaysia if it has access to the following rights. One of the rights is you will need to observe the foreign ownership condition and general guidelines for operating this type of business in Malaysia. And you must own more than half of voting rights in another company. You must own at least 50% of the share capital to the subsidiary company too. A Malaysian holding company is only considered as an attractive investment if the profits are exempted from capital gains tax. If income derived from the dividends are repatriated by the subsidiary to the parent company. If dividends are paid out by the subsidiary to the holding company are exempted from the withholding tax. Reporting tax and taxation. In the holding company, there will be investment company, consulting company, and trading company. Subsidiary company, it is a company owned and controlled by other company. Owning a company is called a parent or holding company. This is an example of a holding company. The activities that are permitted by holding companies in Malaysia include securities, stocks, shares, deposits, loans, immovable properties, and perform management service such as accounting and support. Ultimate holding company is a body corporate that usually have a majority shareholding and has control to another company. A UHC is not a subsidiary nor a corporate. Examples of ultimate companies in Malaysia are PayPal, Visa, and MasterCard. Wholly owned subsidiary. A wholly owned subsidiary is a company whose common stock is completely 100% owned by the parent company. Wholly owned subsidiaries allow the parent company to diversify, manage, and possibly reduce its risk. In general, wholly owned subsidiaries retain legal control over operations, products, and processes. Here are the examples of wholly owned subsidiary, which includes the Volkswagen and the Big Group company in Malaysia. Related companies in Malaysia. Section 7 provides that companies are deemed to be related if one company or the other company is a holding company, subsidiary, or a subsidiary of its holding company. Conclusion: a limited company liability is unlimited, but its members' liability is limited. The liability of a member of a company limited by shares is limited to the amount of unpaid of his shares. The liability of a member of a company is limited by guarantee and is limited to the amount that he undertakes to contribute even the company is wounded up. An unlimited company's liability is unlimited. Its members are also liable for all the debts of the company. An unlimited company can be converted into a limited company, but a limited company cannot be converted into an unlimited company. A private company has the word Sendirian or SDN as part of its name. A private company is a company limited by shares with not more than 50 members. There is a restriction on the transfer of the shares, and it is also prohibited from offering its shares to the public or inviting the public to deposit the money with it. A public company is a company other than a private company. It is not required to have any restrictions on the number of members or the transfer of its shares. It can also offer its shares to the public and invite the public to deposit money with it. The name of a public company shall end with the word Berhad or BHD. Some of the major differences between a private and a public company are as follows. Minimum numbers of directors in a private company is 1, and in a public company, the company is required to hold its annual general meeting. Members of a private company may pass resolution at a meeting or through circulation, whereas members of a public company may do so only at a meeting.